Namaste, welcome to 183rd episode of AAA Weekly Webinar Series. I'm Anil Goel, founder of AAA Insolvency Professional LLP and the other entities. Today, we are going to discuss about one landmark judgment from Honorable Supreme Court. That is in the case of Mansi Brar Fernandes versus Shubha Sharma. This judgment was delivered on 12th of September 2025 by two wonderful judges of Supreme Court, that is Honorable Justice J.B. Pardiwala and Honorable Justice R. Mahadevan. Both these judges have been delivering wonderful judgments, and one judgment they have delivered next week was in the case of SARFAESI, which also we have covered in our short videos. Now, in this judgment, this is a judgment in the case of a corporate debtor called Gayatri Infra Planner Private Limited, and the question of law was in fact not very huge, but the most important part of this judgment of Honorable Supreme Court is that these two judges has given a kind of directions to union government and also to state government for the purpose of various reforms in real estate cases and in fact real estate industry. So this is what we are going to discuss today in this particular webinar. So thank you for being with us. You must subscribe to us. In case you would subscribe, you would get update on all our contents, mostly on SARFAESI and insolvency and valuation. So going forward, we would say that this is a combination of two appeals, and in fact it was in two cases. One was filed by Mansi Brar Fernandes, again as a home buyer, and the other was filed by Sunita Agarwal, again as a home buyer. The question of law before the Honorable Supreme Court was whether the applicants, means Mansi Brar Fernandes and Sunita Agarwal, qualify as genuine home buyers, financial creditors as defined under Section 5, subsection 8 and clause F of Insolvency and Bankruptcy Code, or are speculative investors disentitled from initiating CIRP under Section 7. This was the primary legal issue before the Honorable Supreme Court. The other issue was regarding the cut-off date of ordinance that we are not discussing in this episode because that is not applicable to the industry as such. That was applicable to a very specific case. Now, the Supreme Court has given a lot of observations in this case. I will first see the observations and then I will go to the facts. So, the observations of Honorable Supreme Court in this case was the court held that the appellant, that is the Mansi Brar Fernandes and Sunita Agarwal, are speculative investors and are not genuine home buyers, affirming the NCLAT's finding on this aspect and upholding the reversal of NCLT admission under Section 7 of IBC. In fact, when these two home buyers in different corporate debtors, they submitted an application before NCLT under Section 7, NCLT passed an order commencing corporate insolvency resolution process of these two companies, and one company is the Gayatri Infra Planner Private Limited, and the other company is I'll just let you know the other company. So in this case, the Supreme Court had said, on the facts and law, it is evident that both appellants are speculative investors. Their claims are in the nature of recovery, not insolvency resolution. Consistent with Pioneer Urban earlier judgment of Supreme Court, consistent with Pioneer Urban, speculative investors cannot be permitted to trigger CIRP, as this would undermine revival, destabilize projects, and prejudice genuine home buyers. So this was the main held portion of the Supreme Court order, and then however it set aside the NCLT's finding on inapplicability of the 2019 ordinance. We said that we are not going to discuss that. The Supreme Court in fact further held that further in this case the court issued extensive directions for real estate reforms, emphasizing the right to shelter under Article 21 of the Constitution of India. Now, this is the most important part of this judgment. Shelter under Article 21 of the Constitution of India, and the Supreme Court kept on saying one thing, that the Article 21 cast upon the state to ensure, a duty is casted upon the state to ensure access to adequate housing, particularly for weaker section. Thus, the state carries a constitutional obligation to ensure timely project completion, protect homebuyer from exploitation, and enforce housing rights effectively through RERA and other mechanisms. In fact, the paragraph number 20.1 of this judgment says, a home is not merely a roof over one's head. It is a reflection of one's hopes and dreams, a safer space for a family, a refuge from worries of the world. With India rapidly industrializing and the rural to urban mobility proceeding at lightning pace, the demand for housing has risen sharply. Further, in paragraph 20.3, Honorable Supreme Court says, it is therefore imperative that the life saving of a common person culminates in timely possession of their promised home. Article 21 of Constitution of India would mandate nothing less. Further, the sentiments of Honorable Supreme Court goes on. It says in paragraph 20.4, thus it would be thoroughly erroneous to treat home buyer as a mere commercial transaction, or worse, to reduce housing to a status of speculative instruments such as stocks, debentures, futures, or options through creative contractual devices. The Supreme Court is indicating that in this particular case, the kind of contracts, the kind of MOU, it was basically used as an investor would use. Investor who wants more and more return, but not as a home buyer who wants possession, who want to live in that home. So that is where the Supreme Court is kind of distinguishing. It further says it is fundamental human need. The right to secure peaceful and timely possession of one's home is therefore a facet of the fundamental rights to shelter enshrined under Article 21. Further says it is imperative that RERA authorities are not reduced to toothless tigers. They must be equipped with adequate infrastructure, empowered tribunals, and effective enforcement mechanism so that their orders are implemented swiftly in letter and spirit. Finally, the court also said the court ensured that the dream home of Indian citizen does not turn into a lifelong nightmare. So this is something which after all this sentimental observations, Article 21 of the Constitution of India, then the Supreme Court has given directions to Union of India and it has been this judgment has been forwarded to Cabinet Secretariat of India and also all chief secretaries of all states of India, and the directions which has been given to all this government, union government as well as state government, are very, very important. I will cover one by one all these directions which has been given in this judgment, through this judgment, to Union of India and to state governments. Supreme Court says NCLT and NCLT vacancies must be filled on a war footing. Government must create dedicated IBC benches. Engage retired judges temporarily. In case the judges are retiring, they should be engaged temporarily so that the capacity sustains and the capacity doesn't diminish for the time being. On the infrastructure update, the Supreme Court says that the Union government to file a compliance report within 3 months on NCLT, NCL80 infrastructure improvement. Report within 3 months. Further, the Supreme Court says the expert committee to be formed in 3 months under a retired High Court judge with experts, and this committee should have experts from Ministry of Law, Ministry of Housing, domain experts in real estate, finance and IBC, and persons from Niti Udyog, National Institution of Urban Affairs, HUDCO, Human Settlement Management Institute, that is a research wing of HUDCO, IIM, NLU, National Law University, as well as 2 industry representatives to suggest systemic reforms, and the report has to be given in 6 months. This is the direction to Union government. Further, as regards RERA, Supreme Court says the states to ensure RERA are well staffed with legal and consumer experts. Strict diligence before project approval should be ensured so that no project is approved without a diligence. Regarding real estate IBC guidelines, IBBI, Insolvency and Bankruptcy Board of India, to frame specific rules for real estate insolvencies with RERA consultation. Also directed that the CIRP to be project specific. Mechanism for possession, handover to allottees of completed units. They are saying that the mechanism should be there, that if the units are completed, should be handed over to allottees. Then the government should also consider a fund under NARCL to expand SWAMI for bridge financing, CAG audit to ensure proper use of that fund. So one fund that we have already for financing real estate cases, that is SWAMI, and the other fund which is proposed is under NARCL. NARCL is commonly called as bad bank. Allottee representation to ensure allottee representation on committee of creditors to ensure fair and conflict-free representation of allottees in COC. Then the scrutiny of Section 7 petitions. NCLT to verify bona fide home buyers versus speculative investors at the admission stage. And the speculative investors should not take the advantage of insolvency law. Similarly, digital systems, government to enable e-filing, video conferencing and case management for IBC matters. Even the IBBI is also thinking about it, and I think it is at a advanced stage that a digital system would be introduced to manage IBC cases. Registration and protection, the new housing transactions to be registered after 20% payment. Special affidavit required for senior citizens in risky contracts. In fact, in Maharashtra, most of the allotments are done based on a registered agreement. However, in North, the agreements are not mandatory. So the Supreme Court says that the government should make it mandatory if 20% payment is made. Then escrow for early stage projects, the buyer's fund should be kept in an escrow account and it should be released as per RERA regulations, as per the approved standard operating processes. There are further reforms which has been guided by Honorable Supreme Court. The reforms are early warning system, the IBBI to adopt Basel-like early warning and pre-bankruptcy restructuring framework. Uniform RERA rules should be introduced to ensure uniformity across states to remove ambiguities and strengthen RERA. Now, the housing boards, urban authorities, and the central public sector undertakings to create dedicated units to revive stalled IBC projects. So, all this like housing boards, industrial development corporations, all these companies should have their revival wings, including Noida Authority, Greater Noida Authority, or even Jamuna Authority. Then again the indigenous expertise strengthen collaboration with Indian think tank and institutions to build local restructuring capacity. Government again says, the Supreme Court again says, the government to set up NARSAL-like body or PPP, public-private partnership model to take over and complete stalled projects. Use unsold units for PMAY or government housing. Now this particular judgment has given all these reforms, directions to government, and all these directions and reforms which has been directed by Honorable Supreme Court, it has actually been communicated to Cabinet Secretary of India so that the Union of India can take appropriate actions, and also to all the Chief Secretaries of all states. Now, on this particular case of Mansi, Brar, Fernandes, what is the difference between speculative investors and a genuine home buyer? Now, the Supreme Court has given a very detailed directions on or detailed classification of speculative investors. Determination of speculative investor depend upon case to case, and the factors which can be considered for determining whether it's a speculative investor or a genuine home buyer would be as under. Number one, the nature and the terms of the contract, whether it is an MOU, whether it is a builder-buyer agreement, whether it's a tripartite agreement, whether it's an investment agreement. So the Supreme Court says that it should be a builder-buyer agreement. It should not be an MOU. It should not be a loan agreement. It should not be an investment agreement. It should be a builder-buyer agreement to identify a genuine home buyer. Number of units purchased by one person or a group of parties or group of entities, that is also a very important factor. Nobody, no genuine home buyer will book, say, more than 10 units of a particular building. If it is more than 10, then it should be considered as not a genuine home buyer. It should be considered as speculative investors. Then we have the presence of assured returns or buyback arrangement. If the agreement says that the builder will give us the assured return, maybe 24% or maybe 20% or even more than that, or when the agreement says that either there will be a buyback at a particular amount or that particular amount will be refunded along with the post-dated check. So that means at the stage of the entering of that particular arrangement or agreement, there was an intent of taking it back, or there was an intent of even giving it back to the builder. So that was only a kind of financing arrangement. That was not an arrangement for taking a home or for buying a home for yourself. Then the factor comes is the stage of the completion of the project at the time of investment. The stage of the completion of the project at the time of investment and existence of alternative arrangements in lieu of the possession. Like possession of a dwelling unit remains the sine qua non of the genuine home buyer's intent. In case the possession is not the intent, that cannot be considered a genuine home buyer. That has to be investor or a speculative investor, which is differentiated from the home buyers. Because see, the home buyers can start Section 7 application. Speculative investors cannot use IBC for their recovery process, because it has already been held by Pioneer Urban that a speculative investor should not use IBC for the recovery of the investment made by him. Similarly, so therefore, what exactly the Pioneer Urban Land and Infrastructure Limited versus Union of India judgment says, the speculative investors are those who seek refund or profit without an intention to occupy. Such arrangements artificially inflate demand, fuel asset bubbles, and prejudice genuine home buyers. In fact, the Pioneer Urban judgment defines a speculative investor as one who intends to evade possession and jump ship, or one who is not genuinely interested in purchasing a flat or an apartment. Any allottee who, from the inception of the agreement does not intend to take possession or who later abandons such intent falls within this category, within the category of speculative investor. Such an allottee is primarily concerned with the refund or profit and not with completion of the project. Thus, determination of whether an allottee is a speculative investor must be holistic, having regard to the terms of the agreement, the allotment letter, the payment terms, and the overall conduct of the allottee. All this has to be very clear. In fact, Honorable Supreme Court, in fact, has given reference to very, very old judgments regarding speculative investors and genuine home buyer. In fact, the Supreme Court has also referred a case called Madhubai Amathalal Gandhi versus Union of India, and it is as old as 1961 case, which actually the court has observed at that time also, unlike financial markets, where speculation may sometimes serve a liquidity function, speculations in residential housing undermines stability, fairness, and the very object of housing development. On the one hand, to mislead gullible individuals and seasoned investors. On the other, to jump ship when the market turns or to hold developers to ransom by invoking the IBC as a coercive recovery mechanism, thereby creating a situation of heads I win, tails you lose. So even in this Pioneer Urban Land and Infrastructure Limited case, even in that case also the Supreme Court in fact referred the distinction between speculative investor and a genuine home buyer. And the Supreme Court in fact has held in that case that the speculative investors cannot be permitted to misuse the code as debt recovery mechanism. RERA protects individual investors by enforcing project obligations, while IBC operates in REM to revive the corporate debtor and protect all stakeholders. Once a prima facie default is shown under Section 7 of IBC, the burden shifts to developer to prove that the allottee is a defaulter or the process has been invoked fraudulently, maliciously, or by a speculative investor. The court distinguished between genuine homebuyer, who is entitled to invoke IBC, and a speculative investor who cannot misuse IBC as a debt recovery tool. Developers may also invoke Section 65 of the IBC against fraudulent or malicious initiation of CIRP or filing such applications. The criteria for identification of speculative investors are also has been discussed multiple times. The court in fact referred one case which is P. Ramanatha Iyer and is a law lexicon which defined speculation as a risky investment of money for the sake of and in expectation of usually large profits. A speculative investor is therefore one who enters into an arrangement with the expectation of unusually high profits and engage in activity in the nature of business or trade rather than with the intent of occupying a dwelling unit. Now, the court referred to Duni Chand Rataria versus Buvalka Brothers Limited and observed that where there is an actual chain of delivery ending with possession by a genuine buyer, the transaction is not speculative. Conversely, in a present context when there is no intention to take possession, the onus to find another buyer and effect resale is cast on the developer. The indicators given are non-exhaustive, but the principle should be as defined by the Supreme Court in this case. the Supreme Court says that in determining whether an allotee is speculative, a holistic inquiry must be undertaken considering the terms of agreement, allotment letter, payment structure, and overall conduct. Illustrative indicators are as under. 1. Agreement substitutes possession with buyback or refund. 2. Insistence on refund with high interest coupled with the refusal to accept possession. 3. Purchase of multiple units, especially in double digits, inviting greater scrutiny though not conclusive. Special rights, preferential treatment, or unusual privilege conferred on the allotee. Significant deviation from the RERA model agreement, the greater the departure, the greater the likelihood of speculation. Promises of unrealistic assured returns such as 20 or 25% per annum over a short duration. However, it must be clarified that the distinction between speculative investors and genuine home buyers is relevant only at the stage of initiation of CIRP, at the stage of Section 7 application, whether it should be admitted or it should be rejected. Such allottees are not barred from filing claims for the principal amount invested or from pursuing remedies before other fora in accordance with law. So all this has been given in this order. All distinctions between speculative investors and genuine home buyers. When we talk about some of the facts of the case, then it would be a better clarity and conceptualization of the case. Now, in the first case, which is the Mansi Brar Fernandes case, the facts are that there was MOU, and that actually says the possession was never contemplated in the MOU. Investment of 35 lakhs was made with an assured return of 65 lakhs within 12 months. Invested 35 lakhs, and within one year, it was supposed to be a return of 1 crore. That means a profit of 65 lakhs. 4 flats notionally allotted, but no provision for balance consideration. Post-dated checks of rupees 1 crore was also given to Mansi Brar Fernandes, which was dishonored. It was deposited in the bank, it was dishonored. And Section 138 of Negotiable Instrument Act proceedings were also started by Mansi Brar Fernandes. MOU was in substance a buyback contract and not an agreement to sell. Looking into these facts of the case, the CIRP was started. NCL 80 came to the rescue of the developer, and then finally the Supreme Court also upheld the NCL 80's decision identifying Mansi Brar Fernandes as speculative investor. Now let us go to the second case, which is Sunita Agarwal. Now the Sunita Agarwal, in fact, there was also an MOU. Investment amount was 25 lakhs per unit with 25% assured annual return after 24 months. It contained, the MOU contained compulsory buyback and profit sharing provisions. Language of investment plus risk-free exit showed no intent of possession because there was a clause of risk-free exit was assured to Sunita Agarwal by the builder. While NCLT admitted against Section 7 application, NCL 80 reversed that. So the Supreme Court, in fact, again, it said, as I already have said this particular paragraph, it's very important. The Supreme Court said on the facts and looking into the law, it is evident that both applicants are speculative investors. Their claims are in the nature of recovery, not insolvency resolution. Consistent with the pioneer urban judgment of Honorable Supreme Court, speculative investors cannot be permitted to trigger CIRP, as this would undermine revival, destabilize projects, and prejudice genuine home buyers. In fact, there were 4 appeals One was filed by Mansi Brar, and this case was Gayatri Infra Planner Private Limited. And the second case was, it was filed by Sunita, claiming herself as Homebuyer, and it was in the case of Antriksh Infratech Private Limited. And again, both these cases, in fact, in both these cases, cross appeals were also filed by Shubha Sharma and Ashlesh Gupta, both of Gayatri Group. In fact, this company, this Gayatri Group company, finally it has also on 28th of March 2023 against a separate action under section 7 by one Amit Joshi, the NCLT admitted CIRP, and that is presently ongoing. And there is another company which is Anusha Engineering Consultants and Constructions Private Limited, which is the lessee of the land on which this project of Gayatri is coming up. So that particular company, Anusha Engineering Consultants and Construction, that company where we are the insolvency professionals appointed by NCLT. So presently this case is also going on, and what we are trying to say that all these facts, considering all these facts, we can actually say that these were in fact the speculative investors. Now, the appellant means Mansi, Fernandes and Sunita Agarwal, what they argued before Honorable Supreme Court, they said by virtue of section 5, subsection 8 and clause F as amended in 2018, allottees of real estate projects are recognized as financial creditors. They also argued that the amount advanced by the appellants clearly fall within this definition, having the commercial effect of borrowing and involving the time value of money. The fact that builder defaulted in delivering possession or refunding the amount constitute a default under section 7. The existence of buyback clause or post-dated checks does not by itself transform a genuine allottee into a speculative investor. Sub-clauses were drafted by the builder, not the allottees, and allottee therefore cannot deprive them of statutory protection as home buyers. The appellant further contended that the availability of remedies under RERA or Consumer Protection Act is not a bar based solely on the buyback clause, dishonored check and Negotiable Instrument Act proceedings. These do not demonstrate speculative intent. IBC amendment, that says, so all this is basically the contentions of the appellants, whereas let us understand the contentions of the respondents. Now the respondents in this case are the promoters. The promoters are saying that the appellants are speculative investors seeking assured profits and not possessions. Transactions structured for high returns, in some cases 35%, in some cases 25%. Such arrangements are investment contracts, not builder-buyer agreements, and fall outside the purview of section 5, subsection 8, clause F of the IBC, as laid down in Pioneer Urban Land versus Union of India and Binani Industries versus Bank of Baroda. The IBC is not a tool for recovery of money. Their proper remedies like under RERA, consumer forum or civil suits, and not in insolvency. Speculative investors are those who never intend to take possession but demand refund with profit. In both these cases, the promoter said, in both these cases, appellants did not pursue possession but instead insisted on refund encashment of check with hefty interest. It applied to, so this is what exactly when I said the case is in fact a great case given by these two great judges. It actually talks about speculative investor. It also talks about the reforms which are required in real estate industry. It also talked about various reforms like NCLT capacity or NCLAT capacity and infrastructure. So this is a wonderful judgment. I thought that it is better that I bring it to my audience and all those people who love me, and therefore it is all before you. Thank you very much. Do subscribe to our channel, and if there is any query, if there is anything that we can do under insolvency law or SARFAESI law, please reach out. Our email ID is given in the description. Thank you very much.